Thank you very much. We are here for oral argument in Woyton versus Ward, our case number CACV 18-0677. Each side will be allocated 20 minutes for their presentations. Appellant may reserve a portion of that time for rebuttal if you wish to do so. If you wish to do so, you'll need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask that everyone in attendance make sure that your cell phone is off so we avoid embarrassment and counsel's presentations are not interrupted. We've read the briefs, we've conferenced the case. We encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and being posted, so please, as you begin your argument, please state your name and the party that you represent. With that, Mr. Berkshire.
May it please the court, Keith Berkshire for the appellant, Lucas Woyton, who I'll refer to as father. Before I get into my argument in this case, in reviewing the record this morning, I found an order that had been overlooked when we had done the briefing. Specifically, there's an order at IR 153 called Order Regarding Paragraph 38. In our briefs, we state that there were no specific written findings on the record regarding 408 factors. In that order, which was the post-trial practice on this was quite long and so forth and confusing, and we simply had never seen that order before in my office, but it does make some specific findings on the record. So I do need to correct that the statements in my brief that state otherwise are incorrect. Now, I don't believe that this significantly impacts my argument because the underlying main point of our argument is that the court didn't apply ARS 25408 to this case, and that was the error. And specifically, if 408 is applied, the burden would be upon mother to show how relocation would be in the best interest of the child. We are essentially straight taking on the Buen Camino case from 2009 in our argument, based on the belief that ARS 25408A is not a prerequisite in application of the relocation statute, specifically 25408I and those factors. Here, this was argued. The court in various of the post-trial orders did specifically state repeatedly that this is not a 25408 case, that it is not a relocation case because there was no starting point of an order. This had actually been recently...
Counsel, did you raise the 408 issue in your pretrial statement?
The issue of relocation was brought up and objected to not only in the testimony. I have cites to that.
It didn't answer my question, did it?
I don't believe that there actually was a pretrial on this, Judge, from that standpoint.
So there was no mention in a pretrial statement on 408 factors and how the court was supposed to consider them?
Correct. I don't see anything in the record from our side that has a pleading or otherwise, Judge.
Specifically as it relates to the subsequent order of the court in when he was going through some of the issues related to 408, is there anything lacking, specifically a 408 factor that you believe is lacking from that order?
Well, I think that the main problem with the specific statement and holding by the trial court that he's not going to apply 408 is the implicit burden on who has the burden under 25408 to prove that relocation is the best interest. I mean, I think that's the main starting point. The court did mention the factors. I mean, they specifically stated each factor under 25408I in going through it. So from your question, the answer would be no. He did address every item. But the fact that the court didn't think 408 applied can't be overlooked. I can have these.
Well, hasn't he already considered, if he makes a finding, hasn't he already determined by preponderance of the evidence that that particular fact exists?
I think the findings here are completely not supported by the record I mean, the finding has to have a basis. We can't go abuse of discretion, there's a finding, we uphold it. There has to be actually some factual basis in the record of what this was. I mean, I'll point out two of the findings in that. The court specifically found that neither party submitted evidence on whether the child would benefit from a relocation, then finds there's no evidence to support a relocation. So the findings are contrary to each other just in that one finding alone.
Well, except he also found that the child would benefit because of the extended family that exists on the East Coast. I know you have some argument about that, but that is a finding and it is a benefit to the child.
There are 25403A factors and 408 factors that probably have some evidentiary basis in them, but there are also plenty that don't. For example, I mean, one of the big things here, and the timing of this case and the other kind of famous case now that this same judge was involved in literally at the exact time from the Court of Appeals, the Barron case, which is the same judge, same actual issues in Barron of the gender issue, and one of the other ones, which was in that case, the trial court in Barron, the trial court found that who the primary was mattered. The same here, the court repeatedly says mother was the primary residential parent, which was overturned by this court, saying that's not a factor anymore since 2013. 25403A1 or A3, I believe, is the past, present, future potential relationship. So,
well, who is the primary caregiver is a past relationship.
it is, and it's also, by the same token, not supported by the evidence here. We had a child that was a year and a half old where the parties lived together. Then my client, during the pendency of the case, had the child for a year. I mean, it's impossible to say just mathematically that mom was the primary caregiver when my client, under a temporary order, had the child for a year. I mean, there still has to be the findings made by the trial court still have to have some basis in facts here. Just because the court makes a finding there has to be evidence on it, and there wasn't evidence on these things. For example, the other one of which parent's more likely to comply with the orders. My client had to go out of state with a sheriff and fight orders of protection where mom had to try to keep the kid on him to preclude my client after there was a temporary order. I mean, there's no basis when the court simply says, I mean, I can write down, go through all the 408, 3A factors without any evidence. There still has to be evidence in them, which is one of the main issues here, was there's no evidence when they went through the 403A factors in that order that I just stated, the paragraph 38 or 39 order, but there's nothing to support those actual findings. And if you're already misapplying the statute, that you're saying this statute doesn't apply, this is just it's almost like a lip service to the factors of, oh, I made some findings under them. There's nothing still there with the basis that those findings have any factual basis in them. And it gets back to the main issue here again, which is the idea of the Buen Camino versus the Barrier versus Roundtree case, which was coincidentally one of mine, where this court in Barrier stated that, okay, 25403A, contrary to what Buen Camino says, is not a prefatory statement to apply the rest of it. A is for B, C, and D. It's a notice provision. It is prefatory for B, C, and D, but not the rest of them. And this court just a year and a half ago, clarified that in the Barrier case. And we went through a lot of statutory history and statutory interpretation stuff in our brief, where we talk about how 408 has been modified so many times, and what is A now actually was C, and then a B at one point, and go through the history of this that shows that this issue that was raised in Buen Camino is just inaccurate. Number one, Buen Camino, it never was actually argued, so holding that Buen Camino went essentially past what was actually pled and argued there, and it's being held for a broader theory than what was actually argued. Barrier is definitely more recent case and a definitely more applicable, especially considering all the statute changes that occurred since 2009 and in Buen Camino to present. I mean, the statute 25408, the custody statute has been updated 4 times since then.
And I'm sorry.
No, go ahead.
But they've never seen fit to specifically or change or modify our holding in that case, correct?
Well, again, I think Barrier does. I mean,
No, I'm talking the legislature. The legislature has amended this case, they amended that statute how many times since our holding in 2007, and they've never seen fit to make it explicit that 408 applies in an original parenting time determination?
Well, and again, I think if you look at the fact sheet of the last amendment when 408 was modified, it states that it was done with regard to all rights regarding relocation for parents that are entitled to custody and parenting time. a parent is automatically entitled to custody and parenting time, especially under your case, Judge McBurney, the Gutierrez case, where there was no court orders in that case, but the finding that even a criminal interference with judicial proceedings case could occur despite there never having been an order in that case. And so that same standard has to be looked at here. I mean,
But in Gutierrez, we recognize the continuing validity of I mean, we specifically said in that case that 408, that it was not a 408 case because there was no previous order.
correct, you did. And again, I don't believe that actually was a substantive issue of the case. And he also held that 408 should apply in any case where the children are moved at all, whether 408A specifically applies or not. But the more recent case, Gutierrez was a couple years ago, Barrier was last year, and Barrier was the first one that actually attacked this head on to say, you know, we depart from Buen Camino to the extent that it held 408I is not implicated absent satisfaction of 408A. I mean, Barrier is the first one that has really specifically gone after the Buen Camino case saying, okay, this just doesn't make sense. A applies to B, C, and D, not I. I mean, from a logic standpoint, it doesn't make a lot of sense why the legislature would give protections to parents only in post-decree cases. I mean, if the purpose of the legislature's enactment of 408 is to protect against relocation, and I mean, Arizona has a very detailed relocation statute, more than most. I mean, it's one of the things we've been modeled by other states on. It makes no sense, and I mean, we argue it would theoretically be an equal protection violation to say, okay, if you're divorced and somebody wants to move, you're protected, but if you're about to get divorced, you're not? How would that, you can't read a statute that would make no sense to the purpose of the statute that this would only protect in relocation.
And counsel, your argument there is that doesn't satisfy rational basis. Is that correct?
It wouldn't. I mean, I can't fathom
I just want to make sure.
Correct.
I have some sort of more granular question to follow up on Judge McMurdy's. What are we to make of the fact that 408 isn't raised in the pretrial filings by your client? And I appreciate the candor as you started your opening argument that in fact there were some 408 findings made here. I understand your argument about sort of the case law construing the provisions, but on the facts of this case, where does that leave us?
Well, I think that initially, I mean, we have case law that the court's required to apply the correct statute, whether somebody raises it or not. I mean, just because I didn't raise a 403 argument when I went and litigated a custody case, that doesn't mean the court gets to ignore it. And I do, in my reply brief, there is a statement about where the fact that we did not waive this. I mean, it was brought up and specifically brought up an argument by counsel about that this is a relocation case, and it's specifically brought up, and not only at argument trial, it was brought up in the temporary orders hearing, which I think is the first part of this, because initially, dad files the petition for legal separation, says he's a Yuma resident, says mom's a Yuma resident. Mom responds, says she's a Yuma resident. So he wouldn't have any concept that she's actually trying to relocate because she says she's a Yuma resident. It wasn't until the temporary orders hearing on this case that they notified when mom absconded with the kid in May, that it was really, I think it was June 10th, that she really was already relocated. And that was the first time that this was ever brought up. And from that point on, my client's trial counsel brought this up, that it was to be dealt with as a relocation case, specifically in the argument at that temporary orders hearing, and we quote that in our brief, that he argued that this was a relocation case. Again, without pre-trials on either side, I mean, this is you've got an issue on, some counties don't follow the 76 like Maricopa County does or Pima County does, despite whether the rule exists.
I understand. And is your response to I think it was IR 153 that you made reference to the findings there, that the issue there is sufficiency of the evidence for those findings, or is it something more than that?
I think it's a combination of, yes, sufficiency of the evidence, because if you look at, I mean, there still has to be evidence. Just because the court makes a finding, there still has to be some evidentiary support from it. So from the standpoint of like a finding that mom is going to comply with the court orders, uncontested, she tried to take the child out of state. Uncontested, my client had to go get the sheriff to return the kid from Massachusetts. Uncontested, during that same process that my client got the ex parte temporary order, that she went and tried to get an order of protection listing the kid on it. Uncontested, that she had claims about that she couldn't return the kid for Christmas because all the flights were canceled, despite evidence showing the flights were not canceled. So there's just writing down that mom's going to comply when there's the weight of the evidence. I mean, there's really no evidence to support any of those things. One of the things about,
Isn't that all a credibility determination?
well, but even on credibility, there has to be some underlying basis for the evidence. For example, one of the other issues was the court found that my client was unquestionably going to move, despite the fact that the only testimony was his, where he bought a house and liked his neighborhood and had his neighbor even come in and testify about that. I mean, the court presupposes that he's going to move when there's no evidence at all of that. I mean, something that they talked about during the marriage at some point, that they might move to Boston before a divorce, when the only evidence of it is his testimony, I mean, of buying a house. One of the other things is that the finding that the court says that this is frequent and meaningful contact under the statute. I mean, 25103, 40302, and 25408, he gets 4 visits a year. And in the kindergarten, it's even less. I mean, it's the equivalent of saying, hey, I get 20 days a year. That's frequent and meaningful substantial contact. It's not. I mean, there has to be some basis. There has to be some basis in that. The same as the primary parent and the quality of life findings. When the court says there's no evidence of quality of life, but the kid's quality of life is going to be better with mom, there has to be some actual evidence in the record on that. And it's like the finding of, we didn't base anything upon the gender of the case. Again, the fact that Barron was coming out at the same time, same judge, same exact issues raised in Barron on saying the primary mattered and these statements. I mean, you can't make statements that this is all okay and then say, no, but it doesn't matter, when you just affirm that these statements are acceptable. I mean, that's what's happening here, is the findings don't match what actually occurred at the trial and what the actual evidence was. So there's still, even though I get the concept of abuse of discretion, they made findings, we defer credibility, there has to be some basis for the actual findings before you apply that standard. You still look at it, even if it's a mixed standard. But again,
Counsel, just very briefly, I'm looking at the replacement paragraph 39 language, and I understand that the court disavowed the application or the necessity of applying section 408, but the court does go on to say that the previous findings made under 403 and 403.01 include the findings that would have been required. So I understand your sufficiency of the evidence argument, but just quickly, under 403, because the court is required to take into account the potential future relationships of the parties, to the extent a court in doing that analysis considers the subsection I factors, isn't that enough? Does the court need to find that 408 applies, or can that exercise of engaging in that analysis under 403 be sufficient?
I don't think it is sufficient from the standpoint of the legal burden on it. I think in a general 403A case, the legal burden it's just a 50-50. But in a 408 case, the legal burden is heavily on the party trying to relocate. And I think this again goes to, well, Gutierrez is cited all the time for the no temporary order findings, but the relocation case portion of Gutierrez I don't think can be overlooked here, because it goes through and illustrates how important these relocation cases are and the burden and all the impacts of that happens in a relocation case. And I think that Judge Perkins, the same day that order was issued, that the paragraph 38 order, there's the order denying the motion for new trial that goes through and explicitly details why the judge doesn't believe 408 should apply. And that's the legal error here. If you're putting the burden on the wrong person and you're presupposing that it's a fair, just a level playing field in a relocation case, then that burden shift, even if there's some of these findings, is an error. We don't know if the court would have actually applied 408 with the correct burden on mother to prove this, specifically under the Gutierrez line of cases, that they would have actually came up with the same result, even with those factual findings. Because again, under Gutierrez, it really goes through how heavily these relocation cases should be considered. And if you look at the statutory like the Senate fact sheet and things that we referenced in our brief, that how important relocation is in Arizona, and frankly, how difficult it is, I mean, under the Senate fact sheet, and how difficult it really should be given the issue. I want to reserve the last minute of my time, if that's all right.
Very well, counsel, thank you. Ms. Whalen.
Good morning. May it please the court, my name is Lisa Whalen, and I'm here on behalf of the Appali Tiziani Ward. So the mother's position, of course, is that the trial court did not abuse its discretion or commit error by failing to apply 25408 to the facts of this case.
Did he in fact apply 408 to this case?
No, he did not. Judge Roof, I was the trial lawyer as well, and the judge specifically did make a finding in, I believe it was the order denying the motion for new trial, and also in the order that corrected Rule 39, or Paragraph 39, that neither party had pled relocation, and based on neither party bringing up the relocation, that this was a relocation case. It was our position, mother's position, this was not a relocation case from the beginning. And at the temporary orders hearing, I know there's something in the record, in the transcript, where father says that this is not a relocation case either. Our argument was just that 25408 doesn't apply under the facts of this case because there were no court orders in place when the initial litigation started, when the father filed for his petition for legal separation.
But there was an order in place. It was the temporary order. And the temporary order was for Arizona, for the child to be in Arizona.
Right, but the mother moved with the child prior to any litigation, any filings being filed.
So your position was it the initial filing that there had to be an order in place, or just at the time of the hearing on the dissolution?
There would have had to have been, for 25408 to kick in, there would have had to have been a court order in place.
Well, at the time of the dissolution trial, there was an order in place. It was the temporary order.
Right, and the child was in Arizona with the father during that temporary order.
So would that make it a relocation case?
No.
We had an order in place. The order in place was for the child to be in Arizona, and mother was asking specifically that the child be allowed to go with her to Boston.
Correct.
Oh, so explain to me again why that's not a relocation case?
Because at the time, before the parties, and this is what Buen Camino, the holding in Buen Camino was that there was no legal reason why the mother couldn't move to Boston with the child. The parties were still married. There was no court orders in place, and she moved with the child. And that's what Buen Camino stands for. That
Well, that isn't consistent with Gutierrez versus Fox, is it?
No, it's not. But in Buen Camino, the court also said that 25408 could still apply to a case, but it would be at the discretion of the trial court. Gutierrez was a temporary, or it was a special action case, and that was just the temporary order where the judge said that the child would, well, I think in that case the child had to have parenting time in Arizona. But the Court of Appeals, and I think Your Honor was the one that issued the ruling, you said that the mother could not permanently relocate with the child until there was an order in place. And that's exactly what happened in the case at hand. The judge did not let her permanently relocate with the child until after there was a trial on the merits of the case.
But it's more than that, because the court issued an order specifically directing the child to be in Arizona.
Until
we had a severance hearing. I mean, a severance hearing, dissolution hearing.
It's like a severance if you're moving to Boston with a child.
Right. Yes, that's right. And so the child did remain in Arizona until the trial on the merits was finished.
So you have an order, and you have two parents that are living in Arizona, or at least claim residency in Arizona, So explain to me again why 408 wouldn't apply. Isn't that the criteria? An order and the parents living in Arizona?
Well, the mother was not living in Arizona. The mother was living in Boston. She moved to Boston prior to the father filing his petition. And she never came back to Arizona. She remained in Boston.
So I understand that at least at some point in the filings before the court, the mother was claiming Yuma as her residence. At what point did she change the claim to not the fact of having taken the child and flown to Boston, but in terms of what she claimed as her residence? When did she change that, notify the court of that change of residence?
I don't know that there was, well, at the time of the temporary orders hearing, it was made known to the court that the mother lived in Boston. And that she had relocated prior to any litigation being initiated. But the facts of this case are different in that this all happened in June, early June of 2017. The father was due to deploy in July. The marital residence had already been packed up, and the intent was, and the evidence showed, the transcript showed that both mother and father were in agreement that the mother was going to relocate to Boston. Father knew where mother was.
And I understand that, but that anticipates future action, not what's happened already. And I think that's what we're struggling with a little bit, at least from what I've heard from you so far.
I'm not sure I understand the
When,
question.
to repeat Judge Perkins' questions, when did mother let the court know that she had moved to Boston? Had moved, not was going to, but had moved.
It would have been once she was served with the petition for dissolution of marriage, or I think it was a legal separation.
Right.
Whatever.
So right from the beginning, she says, I no longer live here, I live in Boston court.
Yes,
And the record will support that. Not that she was anticipating moving, but that she had moved.
yes.
I thought she filed a petition for separation.
No, he did, Your Honor.
I mean, she filed a petition for dissolution.
She responded with a petition for dissolution.
And in the petition for dissolution, did she claim that she was a resident of Arizona?
I don't recall, but that's what.
The record speaks for itself.
Yes.
Does it make a difference if the burden of proof is on mother in this case? If we deem this to be a relocation case and believe that the burden of proof is on mother to show it's in the best interest of the child for the child to locate in Boston with her, is there a different outcome?
I don't believe so, Your Honor.
And why not?
Well, Judge Roof made the specific findings under 25403, and one of the most important findings that he made, which is also a factor in 25408, is which parent is going to abide by the court orders and ensure that the other parent has frequent and meaningful contact with the child. And the court did address that factor. So he may not have, even if mother had the burden of proof, I believe the outcome would have been the same just based on the facts of the case. The mother, during the temporary orders hearing, made every effort to co-parent with the father. I know that in the facts of the case, the father stated that the mother didn't come to Arizona. That wasn't true. The mother came every month to see her child, took the child back to Boston, and continued to make efforts. And it was the father that was the parent that was more difficult. And when he had the child, wouldn't allow the mother to see the child, made it more difficult for the mother to see the child. So I don't believe the outcome would be any different, just based on the facts and the findings from Judge Roof.
So is that a harmless error? I'm struggling with, do we say harmless error in these types of cases?
I think in this case, well, I still think it's the law that this is not a relocation case.
Okay, and so what if we disagree with you and say there's a burden and the burden is on mother?
Then
Do we still go to harmless error?
I would say yes, it would be harmless error
And what's your best case for that proposition?
because the judge still, even though he didn't specifically say make findings and say under 25408, I find this, he still did make findings under 25408. And that's, I did outline those in my brief, in my answering brief, how those 25403 findings are the same that would apply under 25408. And I think it was the Roundtree case that said, even if the trial court didn't make specific findings under 25403, they wouldn't reverse if the information was there and the findings were there, just not specifically named under the statute. So that would just be the same case here. Judge Roof didn't say 25408, but he still made findings that were in accordance with 25408.
Isn't there a little bit of a difference, though, when you're looking at 403, where the parties are in relatively equal position in terms of the burden and the court's deciding what to do, and 408, if a case is designated a relocation case, that means that the fact of placing the burden on the relocating parent is saying the status quo is not equal between the parties. The status quo is that the child will remain where the child is, which was Arizona, and it is up to the other parent to demonstrate over this burden that it is the right decision for the court to allow the relocation. I mean, aren't those two different things? So the court having made certain findings over here under 403 where everybody's in an equal position, is it really equal to say those findings equate to what the court would have done if this party had to clear a higher hurdle or a different burden?
Well, I feel that in this case, the mother did clear that burden because the judge kept the child in Arizona during the temporary orders. And the temporary orders went into place in July, or I think the last hearing was in September because it spanned 3 days. So from September until February, the child remained living with the father primarily. And when we went to trial, that was part of the case that we presented, was that why the mother should be the primary custodial parent. So I think regardless, I agree with you that the statutes aren't exactly the same, but I think that the evidence was presented to the judge and that the judge made the appropriate findings of why the mother should be the primary custodial parent of the child. So under 25408I4, even though the judge didn't make a specific finding under that part of the relocation statute, he did make a finding that would support that the mother had been the more reasonable parent and made a greater effort than the father to co-parent under the temporary orders. Also under 25408I3, although he didn't specifically refer to the statute, he made a finding that there's no extended family for the child in Yuma. Relocation of the child to Boston would enhance her relationship with mother's extended family, and she would reside closer to the father's extended family on the East Coast.
And while extended family is important, it's not more important than a relationship with the parent, is it?
No, I don't think that that's true, but I think under the facts of the case, the court believed that the mother believed that the father was going to deploy. It was in such a short time frame that the mother left for Boston June 10th of 2017. The father was due to deploy in early July of 2017. The text messages that were admitted into evidence were conversations that transpired in May of 2017, where the father was saying they were in agreement they were going to move to the East Coast. They'd already had a realtor come to the house. The house was packed. The mother still believed that the father was going to be deployed, and there would be no family in Yuma in that event, and that was why the whole agreement came about for the mother to relocate with the child to Boston. I was just going to cover some of the other questions that were asked. There was evidence in the trial record that the father also told the mother to find a house in Boston when she got there, and that was just a month prior to her moving to Boston and a month before he was supposed to deploy to the Philippines. And I already covered the Rule 39, or the amendment to paragraph 39 and the new trial. The 25408 was not pled by either party. And I know that the father's position was that the issue of the deployment was no longer important because the parents were getting divorced, and then the father didn't actually deploy. But the father tried to base that argument on the fact that because of the divorce, he was not deployable, and it came out later the real reason why he wasn't deployable, and it had nothing to do with the petition for dissolution of marriage. Also, the father obtained the UCCJE warrant for physical custody based on false information to the court. He knew where my client was. He even stated in his motion for temporary orders without notice that he knew that the mother was residing in Boston with her father and mother as of June 10th of 2017. So when he filed his petition on June 12th, he knew where mother was located. He didn't try to serve her with the petition for legal separation or the UCCJEA warrant. So he obtained the warrant in June 14th of 2017. He went to a hearing. It's true, mother did obtain an order of protection that was not upheld. But the reason, and it's in the record, the court said the reason it wasn't upheld was that the court found that the case was already being litigated in Arizona. There was never a finding that the mother falsified any information, and everything in her petition, as I recall, it was true information, but the judge didn't make any findings regarding that. So father came to that hearing on June 29th, did not say anything about the petition up until that point. He had her served in the courtroom with the petition for legal separation, but did not say anything to the judge. He could have spoke at that. He had the opportunity to speak at that time. He did not tell the judge he was concerned for the safety of his child or that the mother had absconded with the child, because he knew that that wasn't the case. And from June 29th till July 5th, he waited in Boston. And then on the date that he knew that the mother was flying back to Arizona to have start the temporary orders without notice hearing, he had the UCCJEA warrant executed. So the child was taken, she was pulled over on the highway, and the child was taken from the mother, and they all went to the courtroom. So I think the facts of our case are unusual, and that's part of the reason the judge didn't, based on Buen Camino, it is not a relocation case. Based on Gutierrez, it's not a relocation case. So the judge followed the statute, the case law, and even the Gutierrez matter without saying so, because he had the child reside in Arizona until the final trial on the merits.
Thank you, counsel. Mr. Berkshire.
The IR 27 is where she says she lives in Yuma. It's just a response. The relocation case, transcript 4, page 34, is the first place that this was brought up at the temporary orders hearing. I'm assuming that the questions on this are based on a waiver argument that we didn't put in a pretrial. Neither party put it in the pretrial. And the temporary orders minute entry, I think it was a stipulation, discusses that relocation will be discussed at trial. So I think the waiver argument has gone there. Plus, mother didn't plead it ever. So if there's a waiver, it's on hers. Under Barron, the concept of what happened in May prior to the divorce filing, Barron specifically holds that things changed due to divorce, et cetera. I want to hit with my 10 seconds this concept of the Rule 2 and the expert. The court considered this person an expert, and Rule 2, despite the court saying otherwise, Rule 2 does not waive the application of Rule 702. It is very clear the court's ruling on that is absolutely wrong, and it's a custody factor of her mental health. So the court considering what it thought was an expert for mother's mental health, despite absolute legal error on Rule 2, that 702 does not apply if you don't invoke the rules.
Thank you, counsel. We appreciate your briefing. We appreciate your argument today. We'll take the matter under advisement. We'll issue a written ruling in due course. Court stand is adjourned.